I was told this was a Earth Day panel. Marc Oettinger, I work for University of California, Santa Cruz. I work within a group known as the Innovation and Business Engagement Hub. We're a group housed within the Office of Research, but in partnership with Office of Research and University Advancement. We are the port of entry for investors, industry, and inventors to work on translational and applied areas of research. And within the Innovation and Business Engagement Hub, I'm Assistant Director of Innovation Transfer, so we're a tech transfer function. We work from concept to commercialization, so technologies from proof of concept through reduction to practice, and this includes software oftentimes, towards translational and applied areas. We are a small team for Santa Cruz against a backdrop of 180 to low 200s of funding, research funding.
Hi, I'm Joel Kehle, and I'm a business development officer at UCLA's Technology Development Group. And you can translate Marc's work and their function to what I do at UCLA generally, so instead of repeating that, I'll focus on some more specific things. I did want to mention, just to give us flavor of the office, is we're 50 people, and yet that's very tiny for UCLA. So my particular role, I manage software-enabled innovation for the whole campus, for all schools and departments. So, you know, your usual suspects would be healthcare and engineering, but that is fun, but there are also things from everywhere. Environmental monitoring, educational platforms. There's a lot of research happening in theater, film, and television for how you use spatial computing in the art of storytelling. Just endless novel things each day across my desk, which is a lot of fun. And so I would say that the difference between myself and my colleagues is that they're focused on physical inventions, you know, and so I sort of say atoms versus bits. So I specialize in the digital realm.
Good afternoon, everybody. Yes, I talk loud, sorry. I wanted to make sure the people back there heard me. Hello, everybody back there. Yeah! I'm Angus. I am the lead intellectual property attorney for the University of California system. I just want to say we had a tough draw coming after Vicki. She's such a great speaker, and her slides, I love how clean your slides are compared to this drivel that I prepared at 1:45 in the morning last night. It's really, really, really good. Yeah, I'm at the Office of General Counsel, where I lead our IP team and also our investments team. And I want to also thank Karla, because I realized as I looked at this slide when it came up, I forgot to include the moderator's name, Karla. So Karla, thank you for so much. My apologies for the omission. Thank you for getting us together and organizing this, this panel presentation. So my principal area of expertise is copyright law. And so, you know, I got involved about 8 years ago in a open source software task force or working group for the UC system. And I think there's at least 1 or 2 members, including Sean DeArmond from UC Davis, who was on that working group. And I think I got pulled in, even though I don't consider myself an open source software expert. I think someone like Heather Meeker, who spoke earlier, she truly is an OSS legal expert. I know copyright law. I lead the State Bar of California copyright meetings every month, and I'm in charge of a couple of committees system-wide on copyright law and copyright policy. But my knowledge of open source software is still, I think, developing. But it did make some leaps when I was on that open source software working group with a few people on this in this room. So that's a brief introduction of me.
Okay, so why don't we get started with you, Marc? So can you tell us how people engage your office? And, you know, what does a typical engagement look like? And, you know, who are the folks? Because, you know, at the university, you've got students, you've got faculty, you've got staff, you've got researchers. So why don't you let us know?
Thank you. Yeah, great question to start. So we, typical to our office, we work with researchers, undergraduate sometimes, but oftentimes it's at the graduate or faculty level. So these are our clients or our customers that are being paid by the university. And because we work off of typically a disclosure form, this disclosure form is kind of our starting point for a lot of folks, but oftentimes we're in the university space talking and interacting with folks, so it could also be pre-form, but that form is usually the codification of what they're working on. So in the software realm, a disclosure form or even an engagement form is more recent. This will come in to sort of describe what the team or the individual is working on and what they want to do. So from a software perspective, so speaking more on the non-invention side, which could lead towards maybe something under patent protection, the software engagement or software disclosure is typically involved for many of the folks in the room, the things that are being discussed today. So it could be open source in nature, it could be more closed or proprietary in nature, it could also be hybrid in the sense that there's other things involved that could have patent implications. And oftentimes, again, we probably will see software disclosures year over year, maybe in the 10 to 15 realm, out of 50 to 60 disclosures. It's probably how we're tracking. And out of that 10 to 15, you may see a smaller fraction that are software open source related. Not to say there isn't a lot of open source happening. Previous work, I was at University of Virginia and also at UC Berkeley. So I think the visibility of our function into that activity it varies from campus to campus and among different teams.
So Joel, would you like to add anything to that?
That pretty much covers it. And there's information about how the disclosure forms differ based on the type of content, but I'm not sure if that's too exciting or relevant. And yeah, I would add that other than disclosures, occasionally people will reach out with startup with. There will be general questions for people that don't have an obligation to disclose about software, and I'm happy to have conversations with them about their appropriate strategy for licensing that. It's just good to understand what people are doing and hopefully be able to steer them on a path which will help them achieve their goals.
And Angus, you?
Well, my engagement with campus stakeholders is a little bit different than what Marc and Joel do. I actually much more likely to engage with them on their legal issues, or if they have some concerns about a particular open source software license, or even just kind of going through some of the legal considerations of openly licensing versus doing some sort of closed proprietary license. So I'm more likely to deal with licensing officers like Marc and Joel, or their bosses, like the IP directors at each of the campuses, and I work with all the campuses throughout the UC system. Or I'm also engage with the delegated authorities at each of the campuses, the ones that actually do make the decisions on whether to license it under an open source software license, a closed license, not to license it at all. And usually those delegated authorities are the IP directors at each of the campuses. So that's kind of my engagement with the campuses.
And I have a follow-up question to this. When you're working with different groups on campus, like when you're working with a researcher versus faculty versus students, does that change your interaction? Like, do you see different levels of sophistication? Or, with a student, they're not really an employee of the university. So you may not have a much, control or much as big a duty to them in advising. So,
Yeah, that's a great question. So again, our customer base or our client base is really the folks who are getting paid. So faculty, postdocs, folks who are working off of grant work or receiving a paycheck. Undergraduates will advise. So if anybody's coming to us and asking questions, we'll certainly advise and point them in a direction. Also, more increasingly with Stephanie and OSPO and other resources, we've combined calls or had combined conversations around that to try to help with what they're trying to do. To answer your sophistication question, Karla, yeah, it varies highly. So some folks are coming in the door with a lot of experience, others not a lot of experience, and so it really varies.
Joe?
Yeah, the other category with students is Anderson, which is our business school, and so we lumped them together. And and still will advise anybody. And then I don't think you can really classify someone's level of sophistication by their role in the university. And so I'll get a varying, someone, if anything, you'll get questions where someone knows they want to do something some way and they saw some really good marketing. You actually have to unpack what their goal is and then explain whether their licensing strategy is going to match that. But I can't look at a PI or a grad student or an undergrad and predict ahead of time what their sophistication is.
Everybody I deal with is much more sophisticated than me, especially the people in this room.
I'm going to interject because I lean on your advice very heavily.
Whether it's good advice or not is a different question, but thank you, Joel.
Okay, so moving on to ownership. We've had a couple of people talk about collaboration at the universities, and I think that's something that's really unique with the UC system. We have collaborations within the UC network itself, collaborations with different groups within a simple one campus. We have collaboration with other universities outside of the UCs and even with industry. So I'm wondering, how does that work for ownership? It seems like ownership could be a little bit tricky. How do you kind of decide, or what goes into making the determination of who owns what? And Angus, will you start?
Well, this is a big topic, ownership. I will try to be very pithy about it, and if there are follow-up questions, feel free to grab me. I'm not providing legal advice, as Karla mentioned earlier, but if you want, I can provide some guidance during a break. So, ownership, big topic, and it's an important topic. And with ownership, of course, comes decision-making about how to license, whether to license something. I think that there is a common misconception within the university, at least, that the person who develops the software code is automatically the owner of the copyright to that code or other intellectual property rights. That is not necessarily true. To determine ownership, you first look at federal law, whether federal copyright law, federal patent law, and the presumption, the default assumption is that anything that you do for your employer is presumptively owned by the employer in terms of intellectual property rights. We muck things up a little bit, so everything that we do, everything that I do is, any copyrighted content is owned by the regents of the University of California. Where things get a little bit more tricky, though, is that we have these copyright policies and we have these other intellectual property policies. And the copyright policy, the system-wide policy that I helped draft, actually changes the presumption a little bit. And for certain types of works, for certain types of personnel, the university will transfer copyright ownership to individuals. So for example, the classic is like a scholarly article or a textbook that a faculty member prepares. Those are going to be owned by the individuals. And there are some tricky lines. One of the things that we did with the redrafted copyright policy that came out in 2021 is to expressly include software as the type of scholarly or aesthetic work that individuals may own. It depends. You have to be considered an academic author. The work itself, the software, has to be considered a scholarly or aesthetic work. All of these are defined, somewhat loaded terms. So I get involved in interpreting whether a particular software package is owned by the university, is owned by the individual PI, might be owned by a third party. There's usually sponsorship funding. There is sponsorship funding, then usually the university owns it, not the sponsor. And then there's, of course, third-party works. Any software package has got typically some third-party works there. So it could be, you could own the copyright to the code, or you can own the copyright to the compilation of the package. So there's a lot of ownership considerations, especially with third parties, when there are other parties that could claim ownership. So again, ownership is the starting point to help determine any of the licensing decisions that flow.
Joel, Marc, do you have anything you'd like to add?
Yeah, I would just say determining that's not trivial. There are lots of shades of gray, and we'll probably talk about that more later. But it's also a very helpful rubric that we've come up with because I don't think I'd share this with you. It really aligns nicely with what is better suited, frankly, for our office to work with as opposed to something where, again, I'm happy to counsel and advise the PI, but if it's a scholarly anesthetic work, in the cases where they own it, it's usually much better for everybody. So good policy.
Okay, thank you.
Okay, so, once you have established the ownership, what factors go into deciding how you're going to distribute? And, is it going to be commercial? Is it going to be, can it be open source? Do the author's intent, how much does that weigh? And the dependencies that you mentioned, how much do you look at dependencies to see, if that should determine how something goes?
Yeah, that's a great question. So I would add actually a third choice. There's definitely the commercial or closed license, and it's a broad bucket. There's open source licenses. At UCLA, at least, a colleague of mine, Angie Kuyak, crafted something we refer to as an academic license. If you want to remember that, you could think about that maybe as a non-commercial open source license, or you could think about that if, open source and Creative Commons got together and had a love child, that's what it would be. So there are these three different options, and I'll explain what the academic is in a moment. So the first thing that I have to look at is sponsor obligations. It could be grant funding from the government, it could be NGOs, or it could be sponsored research. And that sponsored research could be under a master services agreement. It's quite common for those to have requirements for what type of licensing arrangement we put on something. It could be as light as a lot of scientific funding can't be licensed exclusively, or it could be a foundation that insists something is open source or insists it's not. There's no, again, you can't really predict. It's just they want what they want, and we have an arrangement with them for that. So that's a driver. We have to obey those obligations. Once I've satisfied that, it's very helpful to consult with the inventors. And that could be a form of discovery, like, oh, I was about to put this out on a website, and it turns out for their scenario that's not a good idea, or they were going to use a license, which wasn't a good idea. But it's also good to understand if someone has a publication pending and what the obligations, again, are of the journal that they want to publish with, or if they want to be an entrepreneur, because there can be strategies that are mutually exclusive depending on the goals of the PI, and that's something that we'd like to honor. So, past that, we look at commercial potential. And is something patent eligible? Do we think it's valuable in the market? And that will also impact what we're doing. And, broadly speaking, even though it is possible to do an open source license and have a patent, our preference, if we're going to patent something, is to do something initially that is closed source. And, if we change our minds, we're the originators, so we can also do a dual strategy. But we make it this far, and it looks like something is going to be huge for the telecom industry, and it's patent eligible. We'll pursue a patent and a closed source license in that case. In my role doing software, the final thing is to evaluate the research impact. There are many, many, many things that I see which are clearly beneficial to the public good, and it's highly improbable that there's a business model there. And so we try to wrap those in something that makes sense. And that's one of the situations where this academic license comes in, the academic license is more for there's lots of collaboration that needs to happen inside the university, outside the university. We want to make this available, but we would like to reserve the commercial rights. And so if you're a non-commercial researcher, if you're an academic researcher, you just grab this off the website, and depending on what the PI wants to do, everything requires attribution, but sometimes they will let one person out from them license it and make changes, and other times it can just spread indefinitely. It really depends on their preference. Just as an example of sort of these research impacts, like right now, I'm working with someone that has some software that will really make peer review for the whole process of peer review much more efficient, and they're getting lots of feedback. And it doesn't, at least for us, make sense to try to wrap something commercial around that. And so there'll be some sort of license, like a VSD license. And so those are all the layers.
Can I just underscore a couple things that Joel just said? The decisions don't have to be a binary, like do you open source it versus close source it? I think Heather was talking about, in response to a question about sometimes mistakes happen. Like sometimes you license it under a particular open source software license, and then, you realize a couple years down the road that was the wrong one. Well, there's been what I think is a great trend, including the academic software license that Joel was just talking about. This is it. It's 4-paragraph license. That's I know it's very a lot of words compared to Vicky's slides, but I purposely screenshot it just to show you that it fits on one page. It lowers the transaction costs because you don't have to have wet signatures for all of these licenses, and it's great for big projects with a lot of academic researchers that are participating in a particular software project. So things are not binary. This is not an open source software license, but it's like an open source software license. You have to use it for non-commercial reasons. Another one that I sing the praises all the time and that Heather Meeker actually helped draft are the Polyform licenses. Huge fan. I purposely kept all of the URLs, so you can see the URL up there. Big fan of Polyform licenses. There's about 7 of them. Here are the 7 of them. They are extremely short licenses. I remember the first time I opened up a Polyform license, I was like, well, where's the actual license terms? Because they're just so short. And if you put them on a Word document, they would be, less than a page long. And they're written in beautiful, plain English. And that's a real virtue of these Polyform licenses, that they don't, they're not like GPL 3.0. Like I've read GPL 3.0 multiple times. There are so many things I don't understand about that license, and I look at licenses all the time. These licenses are beautifully drafted, and this is the main site is here, and there's about 7, and they're all different icons here. And here's the summary of these licenses. So, and then here's the UCLA. UCLA has actually a couple different licenses that they offer here. And this is the website up there. And I definitely point people to this. Angie, I actually helped, I advised Angie, I mean, she hadn't drafted it, but I made some suggestions on this license. And I think I point people to this license as well all the time. So again, if you're early on, and the researcher is not sure whether to open source it, close source it, these types of licenses are a happy medium in between the two.
Right. And I think like you were saying, like Heather mentioned at the beginning, is you can start off with like having your light version being, made available under open source, and having a version that has more functionality, more enterprise use, make that charge commercially for that. So that's something else to think about.
And campuses are doing that. I think campuses are doing dual licensing approaches more and more frequently, which I think is very smart.
Great. Angus, I was going to ask you, you mentioned the Polyform, you mentioned the academic licenses. What licenses don't you favor for open source?
Well, I'm going to get to that, but I'm going to first get to what we did on this working group that I mentioned at the outset as part of my introduction. So if you go, again, it's under the security.ucop.edu URL. There are open source software resources that a working group throughout the system worked on and came up with various deliverables, and the deliverables are circled right here. I was kind of responsible for the OSS chart, which looks like this. And this was intended to be a very easy, I believe in colors. I like colors more than lots of verbiage. And it just is a helpful resource for people to see what are the biggest most risky licenses. The GPL licenses, including a Faro GPL, are the most risky because they have these express patent granting, this is the GPL license 3.0. This is the paragraph and some of the definitions that are problematic from the University of California's perspective. Why? Because it grants a patent to any of the contributors' contributions or efforts that make it into the open source software package that reads on a patent or that's covered by a patent claim, and it's by any contributor. And the definition of a contributor is the copyright holder. And as I mentioned earlier, in many instances, the Regents of the University of California is the copyright holder. So just take, for example, UC Santa Cruz through Marc wants to openly license something under GPL 3.0, and that software, it's relatively rare these days under the Supreme Court jurisprudence, but let's say that there's a patent that applies to that contribution that came out of UCLA. Now, UCLA and UC Santa Cruz, they're different locations, but we're all part of the Regents of the University of California. So we are the copyright holder, and we might have many, many patents that Marc at UC Santa Cruz is not aware of, but that Joel has exclusively licensed. Well, we've exclusively licensed for gazillions of dollars to whatever company, but then we are openly licensing that same patented technology to everybody in the world. That's a problem. Now, the overall practical risk of that sort of scenario happening is not great. Admittedly, it's not great, but we have gotten into some concerns. I remember 10 years ago there was a concern that we may have openly licensed a patent through a GPL or Apache 2 license that was exclusively licensed to a commercial provider, and they were not happy with that. So GPL is the most problematic, and its derivatives of GPL, including a Faro GPL. We used to, in an earlier version of this chart, Apache 2 was red where it says yellow, and we took another look, and we wanted to be more permissive, and so we deemed it ultimately more of a moderate risk. Apache 2 also has an affirmative patent granting clause, but it's not as bad as the GPL 3.0.
What about copyleft licenses? You hear about copyleft, some of you might have heard them as viral licenses or reciprocal licenses. Do you want to talk a little bit about those kinds of licenses and how the university feels about that?
Well, university loves BSD and MIT licenses. I mean, those are university-created licenses. BSD, literally, the Berkeley Software Distribution License, came out of UC Berkeley, and MIT license, I'm sure you guys can guess where that came from. So, Stanford? Yeah, good guess. I think those are good licenses. They have minimal terms. They don't have the express patent grant. The main thing is that, you provide attribution. And I think a lot of people are familiar with that. Those have the least amount of requirements, because compliance is a big deal. There are lawsuits out there for users of open source software who have not complied with the terms. There's a lawsuit against Visio that's happening right now. And BSD and MIT have the least amount of requirements. You basically just provide attribution to the copyright holder, and then you're good.
All right. So let's go on to, well, is there any kind of vetting that you guys do for open source, for the dependencies, to ensure compliance with that?
Yeah, I would say it's not any sort of software. We will have some sort of due diligence process and do a little bit of that on the intake, but certainly we need to assert we have title to something before we license it. And so I do a deep dive, sometimes can be very consuming, going into discovery of every single library that's associated with a piece of software and tracking down all the licenses. And sometimes they're standard, sometimes they're not. So that's a very granular effort on our part. And related to that, becoming more of an issue with anything where someone has trained a neural network where we want to know the provenance of the data. to make sure that there's appropriate rights.
Yeah, just building on some of the comments, also bringing in the viral hereditary licensing aspects of it. So I'm sure Joel deals with this as well. If there is, what are the goals or the aims of the team or the researcher? So if the goals are startup related or they want to maintain, some level of commercial, and part of that strategy or part of the consideration is the hereditary natures of it. So can you, in looking at some of those dependencies, can you rewrite, to kind of keep a certain license type, for example, if you want to kind of keep options on the table. Other times too, researchers kind of goes back to a question or two earlier that researchers want to maintain that commercial aspect. So I want my stuff out there, I want it used, but I don't necessarily want, big Fortune 50 companies using it for free. So it's a discussion, it's a conversation and a relationship that's set up.
Okay, so I think we can open it up for questions right now. So are there any questions?
I think Stephanie's already, sorry. Yeah, perfect. I think Stephanie's already laughing because she knew I was going to ask this question. I actually, my name is Marvin Barksdale. I actually work in a similar role as two of you from at Mass General Brigham in Massachusetts. We love the work that you guys are doing at UC, and it's just amazing to hear about how your offices work. Very similar to how our system works in terms of the intake and representing the PIs. I think we're a little bit different because we sit on that border between the academic medical center and, well, just the complications that are an academic medical center. My specific question, I guess, is going to be specifically around the Apache and the licenses. I love that you guys took the time to develop your own licenses. I'm doing the same work out at Mass General Brigham now. Specifically when it came to like Apache 2.0, I actually gave a talk at the last Linux Foundation about how we had to develop our own MGB 1.0 license to really represent our specific kind of challenges in the academic medical center. The biggest challenge that we saw was in the patent grant for Apache 2.0, and OSI responded as if I was the only person in the world with this issue, so it's really refreshing to see this issue. The one question for you that I have, it seems like in none of the licenses that you guys aren't necessarily even going for OSI approval. Like, you're trying to serve your community the best way you can. I'm curious about that, and kind of, have you considered that? Like, what are the implications?
I would say we're not interested in OSI approval because the requirements are truly open source. There can't be a non-commercial limitation, as you know. OSI, as folks know, open source initiative. So no, we're trying to find a way that works for us, that is in between a closed source, which is can be time intensive also because of the negotiations back and forth on a software license. I've seen their campuses software licenses that are a bit on the longer side, 15, 20 pages, and there's a lot more room to negotiate by the counterparty. And so the idea of this was to lower the transaction. This is it. And I don't think we make changes to it. And it's very generous because it's free. And we just ask that you provide attribution. It's modeled somewhat after the BSD type licenses, like the BSD4 or BSD3 paragraph license, but it's non-commercial. BSD does not require a non-commercial element, as folks know. So it lowers the transaction cost. We're not interested in having it truly OSI approved. And I encourage other campuses or other institutions, higher ed and academic medical centers, to take a look. I don't know if this is Creative Commons licensed. By the way, this entire PowerPoint is Creative Commons licensed, so anybody can use this to their heart's content. But Polyform is another, as I mentioned, Polyform, these licenses, I'm telling you, they are, Heather and one of her friends, Kyle Mitchell, they drafted these beautiful, beautiful licenses that are plain English. So any of these are good, depending on what you're doing. There's the internal use license that I've pointed people to. There's a non-commercial license that's sort of similar to the academic non-commercial license that I just showed you, and some of these others that I think are excellent.
One second, quick follow-up is, what if the NIH kind of, who's getting very close to this, starts to push towards them funding OSI licenses? Right now, it's kind of gray. They're like, we'd like to see the software that we fund be open source, but what if, which is on the table, what if they make that next step and say, hey, in order to get NIH funding, well, we're going to need to see an actual OSI approved license?
I think it's a great thing because BSD and MIT are OSI approved. I don't know if you guys have further thoughts here.
I definitely like to preserve commercial rights, and that's because I love when grad students get paid. Because our goal is to create and disseminate knowledge, and one of the ways you do that is making the information available. The other way is to fund the next innovators, all the people that are getting PhDs. And in fact, if you, we're not on that page anymore. If you go to the page with our academic license on it, we actually do, when we first created this, we recommended the BSD license for people that were publishing. But what I found in digging into their terms or interacting with any of the journals is they've accepted the academic license. So their goals and ours are aligned. So we'll see what happens.
I was just curious from your system, so does the academic nonprofit that satisfies your needs in the hospital systems?
The academic nonprofit, yeah, I think so. I think it's the OSI. I think a lot of my PIs say, okay, this is great. We can do that in in our libraries. We have one that's very similar, and I like yours. I'm going to compare when we get out of here. But I do think that we're getting a lot more pressure from our PIs that are looking for like an OSI approved, which is why we developed our MGB 1.0, which is a little bit BSD, a little bit Apache, but we worked hard to kind of clean up that patent grant because you touched on the contributor aspect, 100% aligned in that. Also using the word infringement. Mm-hmm. I think when we talk about patent infringement versus copyright infringement, using the word patent infringement can reach beyond the face of a copyright. So we're kind of concerned about that as well. So we would put it in the high. It's still in our high risk instead of the moderate risk. But.
You talking about the Apache too?
Yeah, Apache.
Yeah, it was certainly a high risk consideration, and we I can't remember. Maybe Sean, you might remember, but there was a lot of discussion about moving Apache from the red to the yellow. And that's where we're at. And I haven't heard too many problems since that guidance was released about 7 or 8 years ago. And I do want to emphasize that there's a lot of other information on that UCOP website. So there's the chart that I showed. I haven't showed any screenshots of the chart companion. It's about 5 pages long. It explains the chart in greater detail. It might even address the Apache 2, why we downgraded it. And then there's this guide. I've been thinking about a 9-page guide. These are all hyperlinks that you guys can go to and take a look at what our thinking was about 8 years ago. My understanding is that Stephanie and others might want to refresh this guidance because it is about 8 years ago. I think it's actually stood the test of time because I know it sounds like pride of authorship, but I was getting a lot of open source software questions 10 years ago. And I was having to educate myself reading Heather Meeker's blog entries and articles that she did to get up to speed on open source software. Prior to joining the university 12 years ago, I had never advised on an open source software issue. I may have heard of GPL, I may have heard of BSD, but I didn't know what it was. It's just an alphabet soup from my perspective. And so I had to train myself a bit. And being part of this working group and coming up with these deliverables really helped kind of strengthen my knowledge. So I encourage folks to read that.
Any other questions?
Hi. I recently had occasion to work with the Broad Institute on knowledge transfer. The researcher informed me that everything at Broad was open source licensed, but this came as a pretty big surprise to their legal department. Given the size of the UC system, how do you ensure compliance, particularly in a timely fashion?
I don't know if this is a question for me. Number one, we have some problems with Broad. with the CRISPR stuff that's been going on for about 7 or 8 years, litigation throughout the world. And on top of that, the person who drafted this license right here left UCLA to go to the Broad, and she's part of the legal department of the Broad. So they steal great talent like Angie to the Broad. I'm trying to deflect answering your question because I don't have a good answer about the compliance issue. We comply. It's my answer. I don't have, so I really rely upon I don't make the decisions about whether to open source or not, just to be clear. I just advise on legal issues. I try to manage risks. It's some of these people over here or their bosses that decide whether to open source. We take into consideration the researchers and what they prefer, but ultimately for Regents-owned intellectual property, it's the delegated authorities that get to decide whether to openly license, closed license, do a hybrid, not license, donate it to the public domain. There's a lot of options, and they are the ones making those decisions.
I'd like to add one thing. I think that with the OSPOs, with the development and establishment of the OSPOs, I think that's a place that we could help, do the training, FAQs, kind of be a front line to help people navigate, what kind of license there should be. And of course, we'd be working very close to the tech transfer to make sure that, the policies are in place. So I see that as a big win for the OSPOs.
Hi, Angus. So one of the things that we put into those guidance, I remember because I insisted on doing it, is that if you are contributing to a larger project or a larger community, an open source community, is that you use the license that that community or that project uses, right? You can't have your own code be separate on a different license than the other rest of the project, right? So what if that project is using one of those red licenses? So my question then is, what do you guys want? What steps do we need to take? What justifications or whatever do you want us to do to mitigate that risk so that we can contribute code to an open source project using one of the red blocks there?
Yeah, I have an answer for that, and I wish I included the stuff that was below. I could only include this, so there were a couple legends at the bottom of this screenshot. So just because it's red does not mean you cannot use those licenses or can't contribute to a big project that has a GPL3 or an Affero GPL. What it does require is the informed consent of the delegated authority, and it might be Joel's boss, for example, Amir, at the Technology Development Group at UCLA, who says, okay, we did a quick look to see that there is no Regents-owned patents throughout the entire system that may read on to the contributions that we are providing. And we, for whatever reason, we deem this as a low risk, that there is not going to be any patent probably available for this technology that we're contributing. And if the delegated authority says, okay, it's a risk, but we're okay with it, then you can proceed with the GPL 3.0.
Okay, so more than just that quick glance, what do you need from us, the developers? Right? Maybe this is a question for them that are in the trenches. What do you need from us? Because I've done that before. I've gone and I said I want to do this, and I can't possibly imagine there being a patent even close to what I'm doing, and got shut down immediately because it was GPL3, forget about it. And it wasn't even a question. So I want to, before going and asking again, I want to prime the pump a little bit. I want to get some idea of what can I present that might make you feel a lot better.
So this might vary campus for campus, but if you were at UCLA and doing this, I would open a dialogue with me in the form of a disclosure, because that's such a good checklist to tell me all the things that I need to consider. And yes, Amir would sign it, but he would sign it after I do an evaluation. And we would not shut you down. Our mission is to create knowledge for the betterment of mankind, humankind. And so we would pretty much do what Angus had described and weigh everything out and figure out whether there's any patentable subject matter there that we're interested in. And even though if you weren't collaborating, the things in green are more favorable. If you're joining a project which uses one of those, we would look at the risk and we would make an assessment. And a disclosure is a great way to do that. I mean, you can call and tell me first, but then we need that checklist of information.
Thank you.
Also, I don't know if you do this at UCLA, in some situations, if it's small contributions, right, a bug fix or something, we've assigned it to the individual, and then they contribute. So we move title.
Actually, so Sean, so before we came up with all of this, one of the things that we did that we specifically got on a call with Heather Meeker on 10 years ago was, and it came out of UCLA, so UCLA and UC San Diego were contributing to a big project that had to do with libraries, as I recall. And it was, I can't remember if it was GPL or Apache, and one of the fixes that we did, it's clunky, but you might want to consider it when you talk to Eugene or whoever is at Davis, is it's similar to what Marc just said, is rather than, we don't take any ownership over the contributions. We basically assign all copyright rights and any other intellectual property rights to the contributions to this package, to this project, to the foundation, or to whoever is determining that you have to use GPL, okay? So by assigning or transferring all the rights, you never get into the patent, there's no patent rights that are being implicated of the regions because we have no ownership rights over any of the contributions. So you donate it or you just give it away to the foundation, and that's that. And therefore you never actually implicate the patent rights.
Do you need an agreement with the foundation to do that?
Well, interestingly enough, you don't under strict copyright law. Copyright law, when it's an assignment of rights, an assignment of ownership rights, is just a one-way signature. You need a signed writing by the assignor. Here it would be UC Davis. You don't actually need a counter signature, but it's good. It's a good idea, of course, to have their consent to this arrangement.
We have one more question. Go ahead.
Thank you. I'm Rani from the Linux Foundation. I'm sure you're aware that similar to your red, yellow, and green table, every corporation has their own. And while they'll tell you there's a sophisticated algorithm behind it, it's basically Apache BSD green, everything else red, at least from my experience. So I'm kind of surprised that you say you recommend all kind of licenses, and I was wondering if you ever considered doing some kind of research about the success rate of open source projects that came from the universities as opposed to the license that they're using. Because my gut feeling that everything that is not OSI, permissive, BSD, or Apache is a kiss of death to a project that is looking for adopters. And especially there was someone this morning that said that the key to success to open source project is having some Fortune 500 type company adopt it. So I'm wondering if you have data to contradict my gut feeling that shows that open source projects from academia can be successful even if they use non-permissive license.
I have no data in that regard. None.
Have you considered collecting data and trying to?
Not really.
It sounds like another task for the OSPO network.
Yes, that's right. I think this is a great deliverable for OSPO.
All right, so I want to thank everyone. I want to thank the panel. I want to thank the audience for your great questions. I think that closes up this panel for now.